Every single year, more than 400,000 Americans file for bankruptcy. And here is the part that surprises most people: the majority of them walk away financially better off within 2 years than they were before they filed. Bankruptcy is not the financial death sentence that most people think it is. In fact, for millions of Americans, it is the most powerful legal tool available to them, and they had no idea how to use it. In the next 10 minutes, you are going to learn exactly how bankruptcy actually works, from the different chapters and what they mean, to what you can and cannot discharge, to the counterintuitive truth that the credit industry does not want you to understand. We will walk through who qualifies, what the process looks like step by step, and the one insight about bankruptcy that most financial advisors get completely wrong. By the end, you will understand this system better than most adults in America. Bankruptcy in the United States traces its roots back to the very founding of the nation. Article 1 of the Constitution actually gives Congress the explicit power to establish uniform bankruptcy laws. The first Federal Bankruptcy Act was passed in 1800, largely in response to widespread debt crises following the Revolutionary War. But the modern framework we use today comes from the Bankruptcy Reform Act of 1978, which created the current chapter system and established the United States bankruptcy courts as a separate judicial system operating under federal jurisdiction. This was not an accident. The founders understood that people needed a legal mechanism to escape crushing debt and start fresh. That philosophy is baked into the DNA of American law. There are 6 types of bankruptcy chapters in federal law, but matter most to ordinary Americans and businesses. Chapter 7, Chapter 11, Chapter 12, and Chapter 13. Each one is designed for a different financial situation, and choosing the wrong one can cost you years of your life and thousands of dollars. Chapter 7 is what most people picture when they hear the word bankruptcy. It is called liquidation bankruptcy. A court-appointed trustee reviews your assets, sells the non-exempt ones to pay creditors, and then discharges the remaining eligible debts. The entire process typically takes 3 to 6 months. In 2023, Chapter 7 accounted for roughly 68% of all consumer bankruptcy filings in the United States. The reason it is so popular is speed. You file, you go through the process, and within months your unsecured debts, credit cards, medical bills, personal loans, are legally gone. But here is what nobody talks about. Chapter 7 has an income threshold. It is called the means test. If your income is above the median income for your state, you have to pass a detailed financial formula before you can qualify. The means test was introduced by the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005, which was heavily lobbied for by credit card companies. This single piece of legislation made it significantly harder for middle-income Americans to access the most powerful form of debt relief available. Chapter 13 is the alternative for people who earn too much to qualify for Chapter 7 or who want to keep assets like a home they are behind on. In Chapter 13, you propose a 3 to 5 year repayment plan, pay back a portion of your debts under court supervision, and discharge the rest when the plan is complete. Think of it as a legally enforced debt restructuring. Your creditors cannot harass you, cannot add interest beyond certain limits, and cannot foreclose on your home while the plan is active. That protection alone is worth understanding. Chapter 11 is primarily for businesses, though high-debt individuals can use it too. It allows companies to restructure their debts while continuing to operate. Major corporations like General Motors, American Airlines, and Toys R Us all use Chapter 11 to reorganize. It is expensive, complex, and can take years, but it has saved hundreds of thousands of jobs in the process. Chapter 12 is specifically designed for family farmers and fishermen. It combines elements of Chapter 13 with special provisions that account for the seasonal and unpredictable nature of agricultural income. Now let us get into the mechanics of what actually happens when someone files for bankruptcy. The moment you file, and this is critical, something called the automatic stay goes into effect. This is a federal court order that immediately halts virtually all collection activity against you. Phone calls stop. Wage garnishments stop. Foreclosure proceedings stop. Lawsuits stop. The automatic stay is one of the most powerful legal protections in American law, and it kicks in the instant your petition is filed, not weeks later. After filing, the court appoints a trustee who becomes responsible for managing your case. In Chapter 7, the trustee's job is to identify and liquidate non-exempt assets. And this brings us to one of the most misunderstood parts of the entire system: exemptions. Exemptions are specific categories of property that creditors cannot touch. Every state has its own exemption list, and some states are remarkably generous. In Florida and Texas, for example, there is no limit on the homestead exemption, meaning your primary residence is completely protected from creditors regardless of its value. Federal exemptions exist as well, and some states allow you to choose between the federal and state lists. Typical exemptions include equity in your home, your car up to a certain value, retirement accounts like 401ks and IRAs, household goods, tools of your trade, and in many states, life insurance. Here is something that genuinely surprises most people. The vast majority of Chapter 7 filers, approximately 96%, are what are called no-asset cases. That means the trustee finds nothing to liquidate because everything the debtor owns falls within protected exemption categories. You keep your car. You keep your furniture. You keep your retirement savings. And your eligible debts get wiped out. But not all debts can be discharged. This is essential to understand before you consider filing. Student loans are almost never dischargeable unless you can prove undue hardship under a very difficult legal standard. Child support and alimony cannot be discharged. Recent tax debts, meaning taxes owed within the last 3 years, generally survive bankruptcy. Criminal fines and restitution cannot be eliminated. Debts incurred through fraud or intentional wrongdoing are also protected from discharge. And debts you forget to list on your petition may survive as well, which is why accuracy in the filing process is absolutely non-negotiable. So what does bankruptcy actually do to your credit? Here is where the counterintuitive truth comes in. Yes, a Chapter 7 bankruptcy stays on your credit report for 10 years. Chapter 13 stays for 7. But research from the Federal Reserve Bank of New York found that many filers see their credit scores begin improving within 12 to 18 months of discharge. Why? Because the crushing weight of delinquent accounts, maxed out credit cards, and missed payments is removed from the report all at once. You essentially hit a reset button, and a discharged bankruptcy with zero ongoing debt is paradoxically better for your creditworthiness than being buried alive in unpayable balances. The median income of people who file for bankruptcy in America tells an important story. The majority are middle-class working people who experienced a specific triggering event. A 2019 study from the American Journal of Public Health found that medical bills are the leading cause of bankruptcy in the United States, contributing to approximately 66% of all filings. Job loss is the second most common trigger. Divorce is third. These are not reckless spenders. These are ordinary people who encountered circumstances beyond their control and needed the legal system to provide what it was literally designed to provide: a fresh start. The social stigma around bankruptcy is a relatively modern phenomenon, and it has real human costs. People wait years, sometimes decades, suffering under impossible debt loads because they fear the label. During that time, creditors collect fees and interest, stress compounds, and lives deteriorate. Understanding that bankruptcy is a legal process with a legal purpose, not a moral failing, is the first step toward making rational decisions about debt. Before you go, if you learned something valuable today, hit that like button right now. Subscribe to Legal Brief for a brand new video every single day. We will see you in the next one.